Hello, my name is Lisa Murray, and I'm a family law attorney in Burlingame, California. And I've been practicing family law for about, north of 30 years, let's just say that. My practice is concentrated in consensual dispute resolution, which would be mediation, collaborative practice or collaborative law, and negotiated settlement. I try to avoid my clients having to litigate, if at all possible. And today I am here to talk to you about community property and what is community property. California law defines community property as any property acquired during marriage with some exceptions. Those exceptions are anything you receive during marriage by gift, or anything you receive during marriage by way of inheritance. There are some permutations of community property, which would be quasi-community property is one of them. And quasi-community property is property that California law considers to be community, but is located outside of California, and the state it's located in may or may not be a community property state. It might have some other methodology of dividing the property. So for instance, if you had a vacation home in Arizona, California law would consider that to be community property, and in a divorce situation, the California law would divide it just as though it was located inside the state of California. Another variation of property is mixed property or mixed assets. Now, a mixed asset is an asset that is both community property, meaning that part of it was acquired during marriage, and separate property. And so that might be something you brought to the marriage, something that is separate property, or something you received during marriage by way of gift or inheritance. And these characterizations of property as either community, separate, or mixed come into play in different ways depending upon what sort of assets we're talking about. I live in Northern California, and my practice is in Northern California, so one of the assets that clients frequently have are stock options or restricted stock units that are granted by their employers, by an employer. These assets may be a mixed asset if they were granted prior to marriage, but the 4-year period of vesting, generally it's a 4-year period, happens both before the marriage and then continues on after you marry. That asset then becomes a mixed asset. Another example of a commonly mixed property would be retirement accounts. Again, you work for an employer and you contribute to your 401k, and then you get married and you continue to contribute to your 401k, and your employer contributes to your 401k. That asset then becomes a mixed asset. There's both a separate property component from contributions made by you and your employer before marriage, and the contributions made after you marry, which are community property. With stock options, in terms of how do we divide community property stock options, it really, the division methodology doesn't depend upon whether you work for a public company or a private company, but how to value the asset may vary greatly. If you work for a public company, there's a couple of formulas that are used to determine how much of the stock options were vested either before marriage or during marriage, or if it was a grant that happened shortly before you separated, and some of it vested before separation and then some vested after, and they allocate the options based upon when they vest between the community property belonging to both spouses or separate property belonging to the employee spouse. Now, and similarly, it's the same for restricted stock units. The difference is if you work for a public company, it's easy to value those options because you can just go online and see what the stock is selling at today, and then look at the price that you would have to pay under the grant and sort of determine what the equity or what the value of it is. With a startup or a private company, we allocate them the same way, but because there's no value to those private company stock options or restricted stock units, there's no way to really figure out how to maybe equalize and say, you keep your stock options and just pay me some money, because they currently have no value. So generally, the spouse that works for the startup will hold the other spouse's interest in those options in a trust format, right? What we call constructive trust. And if there's a liquidation event, or if the company goes public and now there's a value, then the employee spouse will, or the non-employee spouse will be able to do something with their stock options. Retirement accounts are also divided based upon separate and community asset or interests, if there are both separate and community. Excuse me. And those are divided by way of a special order that allows you to divide an account that might be in one spouse's name alone, but yet be characterized as a community asset without incurring any of the penalties you might have heard about for early withdrawal. So you don't need to cash in half of your 401k to pay your spouse their share. We can do this special order, and it allows a transfer of retirement assets without incurring any tax or penalties or that sort of thing. Houses are another common asset that people have, and they want to know what to do with the house. Now, if your house was purchased during marriage with savings that you earned during marriage, and that you paid the mortgage with your earnings during marriage, that's a wholly community property asset. But what if you owned the house before you married, and then you continued to live in the house after you married, and paid the mortgage with your earnings? You paid the mortgage with your earnings before you married, and you paid them with your earnings after you married. Well, that's another example of a mixed asset. Although it's treated a little differently than some of the other assets we've talked about, retirement accounts and stock options and restricted stock units. With a house, if it remains in the name of the spouse that owned it beforehand, but the mortgage is paid after marriage with the community property paychecks, the community property earnings, then the community starts to gain an interest in that house, a small percentage interest, to the extent that the principal on the mortgage is paid down. So not the interest on the loan, not homeowners or property tax, and just the principal on the loan. And that community interest shares in any appreciation of that piece of property over the course of the marriage in that percentage interest that the community owns. If at some point after you marry, the house is refinanced and it's now put in both spouses' names, then at that point the property is converted, or we use a word transmuted, into community property. And now the spouses own that property equally. But what happens to all of that equity that the person that owned the house before marriage built up? Because after all, they owned that house before marriage and were paying the mortgage and paying down the equity. That becomes a reimbursement item. And the family code in California says that if you can establish what your separate interest was, what was the value of your separate interest at the time that it was transmuted into community property, that you get that amount of money back as a reimbursement item. It's a dollar for dollar reimbursement. It does not incur any interest. It doesn't share in any appreciation. It's just, if you had a $20,000 interest, separate property interest in the house at the time it was put in both spouses' names, then you get $20,000 back when you sell it. Now you'll share equally in all of the appreciation that happens after it's put into both of your names, as to 50%. Businesses are another question that I get a lot. And in California, there are two methodologies that are commonly used to value if it's a mixed asset, a community versus a separate interest in a business. If the business was started during marriage and one or both of the spouses continued to work in the business during marriage, that's a wholly community property asset, and then it's just a matter of figuring out what the value of that asset is. Valuation differs a little bit from if you were going to sell the business. Valuation for community property purposes is a little different analysis. But what if you owned the business before marriage and then continued to work at that business after your marriage, and you want to assert a separate property interest in that business? Well, that again, we use a couple of methodologies for that, and they're complicated. And so usually what we do is we hire some people called forensic accountants to look at the tax returns from prior to marriage and after marriage, and look at what was the revenue stream that came into the marriage, and determine how much of the business is community and how much might still belong to the person that started the business before marriage. It's complicated and involved, but so I think the lesson to take away with here is that if you have documentation, hang on to it, because again, we look at tax returns and balance sheets and profit and loss statements from both prior to marriage and after marriage in that situation. Now let's turn to debt. So what happens if you got married and your spouse had a lot of debt, and during the marriage you paid that off? Well, as a general rule, that was just a really, really nice thing the community did for your spouse. There's no reimbursement right, and it's just a gift that the community made to the separate person, to the person that had the separate debt. Now, I've had spouses agree to do something a little different than what the law might provide, and if the spouse acknowledges that there was substantial debt paid off by the community that they brought to the marriage, so that would be their separate debt, that they'll take a little less property to acknowledge that and to make it whole. There is one exception to that, which is student loan debt. If you brought a student loan to the marriage and the community paid it off during marriage, there may be a right to reimbursement. Again, like most things in family law anyway, it's going to be based upon what can be established by paperwork, right? How much debt existed at the time of marriage? What was the debt used for? Was there new debt incurred, etc.? But generally, the person that had the student loan and got the education is the person who's responsible for paying that loan back. There is an exception in the law, which is if you have a marriage of more than 10 years after the education was completed. in that instance, then that student loan debt is considered to be community debt. And the theory there is that the community benefited from that higher level of education by virtue of having a higher income stream during the marriage from that higher education, that higher education level. So in a marriage of 10 years, it's possible that the student loan debt may be a community asset. Now, what happens if you have a spouse with a spending problem and they incur a lot of credit card debt during the marriage? Generally speaking, that's community debt. Remember the definition. If it was incurred during marriage, it's community property. Now, there might again be some exceptions, right? If that debt was gambling debt, because instead of going to work one Friday, your spouse hopped in the car, drove to Las Vegas, and incurred a bunch of debt at the roulette table. There could be an argument made that that debt was not incurred in the benefit of the community, that the community didn't benefit from your spouse going to Las Vegas instead of going to work. And therefore, that debt should be assigned to the person who went to the roulette table. And that's generally speaking the exception and not the rule, but there are exceptions. I think as you're learning through this, there's many exceptions. And what about encumbered property? What about the car loan, the loan on the car you purchased? Again, generally speaking, the person keeping the asset that's encumbered keeps the debt too. So you want the car, you pay off the car loan. It may impact the value of that car, right? If you've got a car that has a Kelley Blue Book value of $20,000 and $10,000 worth of debt against it, then really all you own is $10,000. And so that will have an impact on the value of the car. But again, if you want to keep the car, you keep the debt and you pay that debt off. And I guess the other question that I get a lot is, what about the engagement and the wedding ring? Do I either have to give that back or do I get that back? Now, an engagement ring and wedding rings are gifts. So if you remember our definition of community property, it's anything acquired during marriage except by way of gift or inheritance. And so when you give an engagement ring, that's a gift, and so that would be kept by the spouse. And furthermore, that's actually given before the date of separation, and therefore it's not a gift that was acquired during marriage, so it wouldn't be community property. Wedding rings, generally speaking, are given during the marriage, certainly during the marriage ceremony, but again, they're gifts, and most people get to keep their wedding rings. Now, if it's a family heirloom that came from the husband's side of the family, and his mother got it from his father, and it's come down the line, often, I'd say most often, people reach agreement whereby that ring will either go back to the spouse whose family it belonged to, or sometimes it will be saved for the children. So it will be kept in a safe deposit box, or one spouse or the other will keep it. But there's an agreement that when one of the children or the only child gets married, that ring will be offered to the child to use for their marriage. So that's community property in a very small nutshell. It is complicated, and there's lots of permutations. But if you remember the general rule that property acquired during marriage is presumed to be community property, except if it's received by way of gift or inheritance, then you'll have the basic tool with which to at least make an initial assessment. Excuse me. And it's always a good idea to seek independent legal advice about any legal situation that you are entering into. And I want to thank you for listening today.